there are limits. Yes, they should be decided. And those limits are around prorogation. And where he's left the door wide open is for somebody else to decide on what those limits are, and if in this case, the Prime Minister actually went past those limits.
The long-awaited decision on the JCCF's prorogation challenge is here, and unfortunately, it's disappointing. But there's more to this ruling than meets the eye, because while the court dismissed the case, it didn't slam the door shut. In fact, the way this decision is written suggests the judge didn't actually believe it should have been dismissed. Instead of delivering a ruling that shuts down an appeal, he seems to have done the opposite, setting it up for a likely and possibly favorable outcome down the road.
Let's take a look. So, ladies and gentlemen, this is what we've been waiting for the last couple of weeks now. I know that a lot of people have been saying that this is taking a long time, but to put it into context, if you even look at the Tamara Leach case, that decision and verdict has been waiting for months and months and months. I think they're up to, approaching 6 months at this point. So to get a decision in a couple of weeks is actually rather quick. Is it as soon as we would have liked? No, but it is what it is. So this is the official document that was released yesterday that the JCCF had been posting screenshots on Twitter. So what we're going to do is we're going to walk through some of the, we believe, key points in this decision. So the way these are usually laid out is the judge, presents what the applicants or the plaintiff, or depending on the legal terminology and the type of case it is, essentially their assertions, and then he presents his arguments and his reasoning, and then his conclusion as to what it is. So, did the judge dismiss this case outright? Well, the answer is no. And there's some nuance to that, which we'll talk about. But what he did do is something very important, because one of the main issues that the government was arguing, if you were following, was the government was saying right at the outset that the court has no jurisdiction in this in the first place, and the case shouldn't have even been heard because this is a political decision and it has nothing to do with the courts. Well, let's take a look at the first part. So this is paragraph 78 on page 25. This is what Chief Justice Crampton says. Having regard to all of the foregoing, because he laid out 77 other paragraphs, I conclude that this court has the jurisdiction to review the decision, including for the purpose of determining A, the justiciability of the issue of whether the Prime Minister exceeded his authority in making the decision, and if that issue is justiciable, B, whether the Prime Minister did in fact exceed his authority as alleged by the applicants. So what does that mean? Well, what that means is the Chief Justice is saying that for the decision of prorogation and whether or not the Prime Minister exceeded his authority, his power, he's saying, yes, the court does actually have jurisdiction. So he went against the government's assertion on that. That's a good thing. That's a good thing because this potentially sets the precedent up down the road of future legal challenges to be accepted by the court if people choose to raise them, if another prime minister in another government, in another party, in any party, decides to prorogue parliament and they believe that it is unconstitutional. So let's continue with the next paragraph.
The justiciability of the issue of whether the Prime Minister exceeded his authority in making the decision, quote, requires some understanding of the jurisprudence that underlies the claim, which in turn requires a somewhat probing examination of the substantive allegations of the claim, end quote. La Rose, at paragraph 36. Moreover, if the issue with which the court is seized is justiciable, the court must have some understanding of the limits of the Prime Minister's authority to be able to determine whether he exceeded them in making the decision.
So this is where the court's ruling gets confusing, because the court is saying, well, there obviously should be limits on the Prime Minister's power to prorogue, because he said that in the previous paragraph. And that was a concluding paragraph based on all of his arguments. He's saying that, yes, the court has jurisdiction to evaluate this. And the court has the jurisdiction to evaluate this on the basis of if the Prime Minister exceeded his power limit. In this paragraph, he is saying, well, the court doesn't really understand what the power limits are.
I think it makes perfect sense, because they're saying that, well, the court would be the place to determine whether or not those powers were exceeded. So the place is appropriate, but we don't know whether or not those powers were exceeded because we don't know what the limit on those powers is.
Well, and if this was the end of the ruling, this would make sense. But it doesn't, because the ruling continues, and we will explain why.
Paragraph 109. To the extent that the limits of the Prime Minister's authority to exercise prerogative powers are constitutional or otherwise legal in nature, the issue as to whether he exceeded those limits in making the decision that is currently before the court is justiciable. This issue has the requisite, quote, sufficient legal component to warrant the intervention of, end quote, this court. See paragraph 102 above. Paragraph 110. The Constitution or other legal limits that may circumscribe the prerogative to prorogue Parliament provide the objective legal standards against which to adjudicate the issue described immediately above. Those objective standards also ground a legitimate role for the court within the separation of powers. Democracy Watch versus Canada, Attorney General, 2023 FC 31, paragraph 76, Affidavit 2024 FCA 75.
So the court is essentially saying here that there should be a legal standard, but it actually directly contradicts the paragraph that we just read. So in the previous paragraph, it's saying, well, in order to understand the legal standard, there needs to be some probing. And then here it's saying, well, in order to actually evaluate this, the court needs a legal standard. But it's up to the court to determine what that legal standard is. So if the court doesn't determine a legal standard, how can the court evaluate the justiciability, basically the claim that the Prime Minister exceeded his power, without determining what that limit is? This is where the whole ruling starts to go off the rails and get very confusing. Let's continue.
Paragraph 242. Given all the foregoing, the issue of whether it would be beyond the Prime Minister's authority to exercise the prorogation power for the purpose of avoiding a certain confidence vote is best left for another day.
This sets up the next interesting argument that is put forward by the Chief Justice, because one of the arguments put forward by the applicants and by the JCCF was that, well, the Prime Minister exceeded his authority and his power by proroguing Parliament, knowing that there's going to be a non-confidence vote. Now, in the ruling, the Justice says, well, the JCCF admitted that at this current time, the Prime Minister maintains the confidence of the House. But this is a rather weak assertion that the Chief Justice is using to support it. Of course, right now, the Prime Minister maintains the confidence of the House because there hasn't been a confidence vote. That's the whole point. But as the JCCF outlined, all of the party leaders had publicly announced that they intended to bring down the government at the next available opportunity. Well, if that opportunity doesn't come by way of prorogation, then they can't remove the confidence of the House via a non-confidence vote. So that doesn't hold water. But back to what he said, the issue of whether the Prime Minister exceeded his power by avoiding a non-confidence vote is best left for another day. This tells me that the justice is fully intending this question to be decided down the road at an appeal.
Well, and we've already heard from the president of the JCCF, John Carpe, that appeals are likely on either side. And this was when we didn't know what the verdict was. Now that we know the verdict, we would hazard a guess that the JCCF is going to be appealing this ruling.
Well, and they in so much as said so on X yesterday. But this comes back to this whole point. The court has said, the court being Justice Crampton, or Chief Justice Crampton, the court has said, in order to evaluate this, we need to understand what the limits of the Prime Minister's powers are. But then goes on to say, in that last paragraph, we're not going to look at whether or not these specific actions that are being alleged by the applicants are actually exceeding these powers. We're not going to evaluate that. So we're not going to determine what the limits of these powers are. That's like saying to somebody, you need to jump a certain height in order to pass this test. And then the person says, what height is that? And then the person says, I don't know. Well, then how are you supposed to know if you're going to pass the test if you don't know how high you need to jump? And this is where things get really strange. Let's continue.
Paragraph 262. In reaching my decision on this issue, I am mindful of the requirement that the court should refrain from, quote unquote, unduly interfering with the functions of other branches of government. See paragraphs 81 to 82 above.
What does this mean? So there is a concept in our system of government where each branch, although it's supposed to hold each other to account, should not be unduly interfering within the other branches, which makes sense because you don't want one branch of government stomping all over all of the other branches, because it inhibits the entire system from functioning smoothly, and it inhibits each branch from holding each other to account. Fine. The issue here is that this statement and this reference is sprinkled throughout this ruling, and even references the Supreme Court and all of this. But here's the thing. He says that I want to be mindful that the judiciary shouldn't be unduly interfering with other branches of government. But at the very outset of this decision, you say that the court has jurisdiction. So if the court has jurisdiction, then you are interfering. But you've ruled that it's not unduly interfering because you're saying it has jurisdiction. So that doesn't really wash. Let's continue.
Paragraph 298. The applicants failed to demonstrate that the Prime Minister exceeded any limits established by the written Constitution, including sections 3 and 5 of the Charter, or by the unwritten principles they identified. The applicants also failed to demonstrate that the Prime Minister exceeded any other legal limits.
What other legal limits would those be, Justice Crampton? Because you actually say earlier in this ruling that the court has to determine what they are. So if the court has to determine what they are, you cannot then turn around and say, well, the applicants have failed to provide evidence and convince the court that the Prime Minister actually exceeded the limits, which the court hasn't in turn defined what they are. So it's a circular argument. And if you're confused, then that's expected. It's expected because this is a circular reasoning argument and decision here.
Paragraph 301. I understand why the applicants might find the circumstances surrounding the decision to be troubling. This is particularly so in a broader context in which the executive branch has been increasingly drawing functions away from the legislative branch by, quote, the concentration of power to the cabinet and the Prime Minister's office, end quote. See Reginbald and Newman at 3.68. paragraph 302. However, the applicants bore the burden to demonstrate that the decision, viewed in its entirety, exceeded the scope of the Prime Minister's authority. They failed to meet that burden. Now, that last paragraph makes sense to me. If you go to court for a criminal case, for example, it's up to the Crown to prove that you did do what they are accusing you of. It's not up to the defendant to say, no, I didn't do that. I mean, you do have the ability to rebut their accusations, but the Crown is the one who has to prove beyond a reasonable doubt that you are the guilty party.
But we come back to that jumping example. How are the applicants supposed to prove the Prime Minister exceeded the authority when that limit hasn't been defined and the JCCF came in their opening argument? It's not like they argued this at the end. In their opening argument and in their claim that the court needs to determine what are the limits of the Prime Minister's power to prorogue. And the Chief Justice even says they don't really know. And then the Chief Justice says, as we said earlier, well, we're going to leave that discussion for another day. Well, if you're not even going to entertain defining what those legal limits are, you then can't say that the applicants didn't meet the threshold, because there is no threshold. That's the problem. Now, in the first paragraph that Tanya just read, the Chief Justice acknowledges and agrees that there actually has been unduly interference from the executive branch, meaning the cabinet and the Prime Minister, in overriding the legislative branch. And if that's the case, that's incumbent on the third branch, the judiciary, the courts, to step in. That's how this triad is supposed to work. If one branch is siphoning power away from another one, or is acting unconstitutionally, it's on the other third branch to step in.
That's why there's three of them.
Right. So this is how this is supposed to work. So they're saying, well, yes, I agree. And it's concerning that the executive branch is siphoning more and more power away from the legislative branch, and even cites case law to actually talk about that. But then turns around and says, but the applicants haven't proven that the Prime Minister exceeded the power limits, which we as the court are unwilling to define until later. This is bizarre. So, where does all of this lead us? Do we believe that Chief Justice Crampton has written this decision to protect Justin Trudeau and the Liberals? Absolutely not. And I'll tell you why. So everyone's assuming, number one, that Chief Justice Crampton is a Liberal Trudeau appointed judge.
But he's not.
He's
not.
a
Harper appointed judge.
He was appointed by Stephen Harper. So the question must be asked. Okay, well, then is this a fair ruling? Now, the issue here, and what is most indictable, is how this is written, because it's very contradictory that we've gone over. And a ruling this contradictory and this non-definitive doesn't really match the skill set, the experience, and the position of a Chief Justice. What's a Chief Justice? A Chief Justice is the head of that court. So Chief Justice Crampton is literally the head of the federal court and all the other judges that go beneath it. Then there's a Chief Justice of the Federal Court of Appeals, which is separate from that. And then there's the Supreme Court. So you would expect a Chief Justice to approach this type of ruling definitively.
Right. This is not somebody who's fresh out of school. This is an individual who has immense experience and has been doing this for a very long time, many years. And one would assume is also very highly respected in order to hold that position.
And if this person was just trying to protect Justin Trudeau, then what would have happened, in our opinion, now we're not lawyers, but in our opinion, what would have happened is he would have just said, nope, this is not justiciable, meaning the court doesn't have jurisdiction to rule over this. The Prime Minister can do whatever he wants when it comes to prorogation. Case dismissed. It wouldn't have even been heard in court. That's what would have happened. So that's not what happened. And judges normally do not like to be appealed.
No, because it means that they've done something wrong. You can't appeal a ruling just because you don't like it. You have to appeal a ruling based on the fact that something procedurally went wrong in order to achieve that ruling.
Right. And the appeal is usually on the basis of the judge that evaluated it in terms of how they've made their argument and conclusion from a legal perspective. Well, the issue here is from a legal perspective, this is riddled with holes. Complete holes. And they seem to have been drilled into that deliberately because, again, this is a Chief Justice. As Tanya said, this is not somebody fresh out of school. They are very experienced and have handled many cases to the point where they're actually the head of that branch of the judiciary. So what seems to be the case here, this is a theory that we have. Based on this argument, this is what seems to have gone on. The Chief Justice, being a Harper appointee, seems to have been afraid of the political outcome of actually ruling in the favor of the applicants. Why? Look at the firestorm that has been going on since Justin Trudeau resigned and the Liberal leadership race. All the mainstream media has been fawning over Mark Carney. A little bit of Freeland, and whenever Curry Gold comes on, but it's all over Mark Carney. Can you imagine the political firestorm that would have happened if a Harper-appointed judge nullifies Justin Trudeau's prorogation? Now, does that mean that that would have justified this decision? Absolutely not. But it gives an idea as to the reason. So, and I was even saying, while I was sitting in court on X and in the videos that we did while we were in Ottawa, that the Chief Justice wanted this to happen. Wanted this in terms of he saw the arguments there, he saw the merits in them. The government's counters were completely broken. Didn't really even agree with any of the government's arguments in this ruling. So it seemed like he was very much leaning towards, yes, I think this is correct and this should be nullified. So, and then he writes this ruling. I don't think he agrees with the dismissal. I think what happened here is because of all of the political volatility going on, he says, you know what, now's not the time for this ruling to set this precedent. So what I'm going to do is I'm going to structure this argument in a way that it's easily appealable by the JCCF. And it's going to make it very easy for the next court to then, one, determine what the limits of the Prime Minister's powers should be, and then B, evaluate the arguments of the applicants to determine if they in fact merit their application, which is that Parliament should not have been prorogued and there should be a limit on the Prime Minister's power. The Prime Minister exceeded his power and therefore setting the precedent. Now,
this is just speculation on our part.
Right.
But this seems to be the most logical explanation for this ruling that we can understand. It's kind of like in chess. If you sacrifice your queen in order to make the mate, it feels like by giving this ruling, i.e. sacrificing the queen, it prevents us going back to prorogation, where Jagmeet Singh has announced, again, he's flip-flopped, that he will no longer support a non-confidence motion against the government. So instead, if we continue on, we expect that there's going to be an election called next week. And that's the mate.
Right. So, although right now, it is very disappointing for all Canadians and us that this is the way the ruling went. This may actually, at this point in time, be the best possible outcome to avoid disrupting the path that the system is currently on, which is to an election. Brian Lilly just reported today that the Liberal election plane has been wrapped. What does that mean? It means an election's coming.
Well, and we know of 3 Conservative EDAs, and there's probably more, but these are just the 3 that we've had interaction with that we know of that have ordered their signs and are either assembling signs or they're in a warehouse somewhere waiting for that writ to be dropped.
And we also know that the Liberals had set a deadline for sign delivery as well, and it's very, very soon. So if they're not planning on going to an election until the fall or next year, why would they need their election signs now? Why would they need their plane wrapped for the election now? That doesn't make sense. So this is what we're seeing here. So what I expect to happen is there's going to be an appeal by the JCCF. It's going to go to the Federal Court of Appeals. That will be decided after the election happens. And then we're going to get a decision. And maybe it's favorable at that point. Maybe it goes to the Supreme Court and then it becomes favorable.
Now, I suppose the question is, well, if we do go to election or if that March 24th deadline passes before we get a ruling from the appellate court, what's the point? Is it not moot? And I would say that the answer is no, because this sets up what the Prime Minister's limits are for future governments. And I think that's important for Canadians to understand, because we don't want a Prime Minister and a government that can just do whatever they want. We want them to have limits. And as Canadians, we deserve to know what those limits are.
100%. And the silver linings in this ruling is that the Chief Justice says, yes, there are limits. Yes, they should be decided. And those limits are around prorogation. And where he's left the door wide open is for somebody else, which should have been him, but somebody else to decide on what those limits are. And if in this case, the Prime Minister actually went past those limits. So, although this is a disappointing result,
ruling, yeah,
it may be the one that's necessary right now in order for us to get to that election that we need. And then the courts can decide afterwards to hold all future prime ministers accountable and to allow other potential court challenges to be more easily laid at the feet of the court when a prime minister exceeds his authority when he's proroguing parliament. It may actually allow us to hold our government to account in the future, because at this point, Justin Trudeau, he's going to be gone on Sunday.
Well, I mean, he's going to stick around for a little while to show Carney the ropes, but for all intents and purposes, he's done.
So, if I had to trade right now another week of proroged parliament to get an election, I take that deal. But this is our analysis. This is how we view the ruling, folks. Let us know what you think. But it certainly wasn't boring, that's for sure. And I applaud the JCCF for making their arguments. I think they did a fantastic job. They were able to refute virtually all of the government arguments, which is reflected in that ruling by Chief Justice Crampton, and I applaud the two gentlemen that brought this challenge in the first place. And kudos to Democracy Watch and the British Columbia Civil Liberties Association for joining with the JCCF on this. We need more of this to call out the government when they are acting unconstitutionally, and but we need these judges in the judiciary. You need to avoid that which you are trying to say that you don't want to interfere with, which is acting political.
And remember, we're going to follow this as closely as we can for as long as we can. So we anticipate that when and if the JCCF does submit an appeal, that you guys will hear from us about that as well.
Stay tuned.